Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As announced, I'm Alan Lawson. I'll be presiding. To my right is Judge Bill Palmer. To my left is Thorpe. We have 3 cases on the docket. The first is a criminal case. Each side has 15 minutes, and if counsel want to come forward for that. The second 2 cases are civil. Each side has 20 minutes for the civil case. If you are the appellant and want to try to save time for a rebuttal, if you'll let me know, I'll set the clock so that the light turns yellow. We have a green light, yellow light, red light system. When you're into your rebuttal time, it'll be up to you to, at that point, decide whether to save that time or continue using it during your initial argument. And then when the light turns red, your time has expired. First case on the docket is Christopher Linus Fries versus State of Florida. Counsel, whenever you're ready.
Good morning. May it please the court. Matthew Kaczurgis on behalf of appellant Christopher Fries. I'd like to reserve 5 minutes for rebuttal. Christopher Fries was charged by indictment with 1 count of first-degree murder resulting from the shooting death of Paul Cruikshank. The facts of the case show that the 2 gentlemen met on the evening of September 10, 2011 and proceeded from one location in Volcano Beach, Florida to St. Augustine, an establishment called the Giggling Gator. At the Giggling Gator, an altercation ensued between the men, and the big issue for trial, the million-dollar question, is what happened. At trial, Christopher Fries asserted self-defense, and in conjunction with that, he stated his theory of defense was that once the altercation ensued, he had recently suffered injuries from a motorcycle accident and felt that he was in grave harm. As a result,
take the facts in the light most favorable to the state. Would you agree?
To support the jury's verdict. Yes, sir.
I wonder why then in your statement of the facts, in your brief, you seem to present the statement of the facts in the light most favorable to your client. You seem to use his version as the statement of the facts as opposed to the facts in the light most favorable to the state.
Well, in this case, there was no eyewitness testimony other than that of Christopher Fries. Although there was a gentleman, Daniel Garrett, that testified to a portion of the altercation between the 2 gentlemen. He left and went inside the business that he worked neighboring for a period of approximately 2.5 minutes between his 911 call in the business and the report of the law enforcement officers.
These 2 witnesses that heard your client make a statement that was inculpatory, right?
The "I'm going to effing kill you" statement, Your Honor?
That's a pretty linchpin issue, right?
Well, no one testified that it was Mr. Fries that made that statement. They just stated they heard that statement. They couldn't state whether it was Paul Cruikshank, the victim, or whether it was Mr. Fries that made that statement. So, as a result of the incident, Mr. Fries was arrested. Following his arrest, he was taken into the police station. Mr. Cruikshank died shortly thereafter and was taken to the medical examiner's office. In the course of the investigation, Mr. Fries gave an account of what had happened to the law enforcement agents. And during that account, he was interviewed by a Detective Apel. And during that interview, he was drawing a diagram of what had happened at the scene. This information was being reported back to the lead detective, Detective Simpson, whose testimony at trial was that he was to follow up on all of the information and all evidence funneled through him. So the substance of Mr. Fries' statement was given to Detective Simpson, who went to the medical examiner's office. Now, certain evidence was supposed to be collected, certain evidence apparently was collected, but significantly other evidence was not. Dr. Bulick, the medical examiner, testified that when Mr. Cruikshank came in, just as he had done in every other case, he swabbed the hands for gunshot residue, sealed it, and provided it to the detective. Simpson stated that he never obtained nor ordered gunshot residue. Dr. Bulick stated the only time he would not get gunshot residue, which is not what he stated in this case, he stated it was a...
Can I go back? I'm looking at my notes and you have me confused because I thought that Daniel Garrett identified, though not by name, by description of physical appearance and clothing, your client is the one who pulled the handgun, put it in the face of the deceased, and was threatening. Is that?
That's what Mr. Garrett testified to.
Okay.
He did not, however, state, he testified that there was an ongoing altercation that as it got louder, it drew his attention. He did not see how it started. He was looking through a gap in a fence, and if you look at the record, apparently there was a truck standing or parked in front of this gap. But he says through this gap of the fence for this brief period of time, he saw Freeze pull a weapon, and I think he went so far as to state put it under his chin and began marching him back to a fence. Then he left to make a 911 call. What he did not see was how it began, which Freeze's contention.
You're saying that he didn't also identify by description and clothing that it was your client that uttered the threatening statement?
Not the one that Judge Torpy had just alluded to right before the fatal shot, because he was inside the store. He couldn't have heard it. And so what you have is evidence from the medical examiner that there was gunshot residue given to the detective that was never preserved, wasn't in the record, and Detective Simpson said was never acquired, but you have the evidence from the medical examiner that indeed it was. Given that this is a hotly contested self-defense case where Freeze has told the detectives that there's a struggle occurring, and mind you, between Garrett's observations of the incident, his going inside and calling 911, Officer Shipp, the first responding officer to the scene, and the gunshot, approximately 2.5 minutes elapse. So this isn't a very quick execution. There's 2.5 minutes of unaccounted for time where the only person that could provide any account was Mr. Freeze. And so Freeze is telling law enforcement officers there's a struggle, we were wrestling over the gun, and it accidentally discharged. The gunshot residue that was obtained by the medical examiner would have been very relevant and probative in this case to show that indeed, and corroborate Freeze's story, indeed a struggle existed. Likewise, there was other evidence that was failed to be preserved and tested. There was the nail clippings of Crookshank. Significantly, law enforcement didn't take any nail clippings from Freeze, so they couldn't have been tested. That evidence was lost. And
Is it lost evidence if your argument is that the police didn't undertake some investigation or do some tests they should have taken? Or is it simply an argument that you can make based on that gap?
under the circumstances, and it depends on the specific evidence, I think, Judge, with respect to the gunshot residue, where they knew that this was an issue and they failed to take it, that would be destruction of evidence by the law enforcement agent. And then the question becomes...
Do you have a case like that? Because, I mean, the cases that I've seen treat that as an argument that there's a sloppy investigation which should, you know, which should aid you in arguing reasonable doubt. But I've never seen a case where the failure to take gunshot residue was a Brady violation.
Well, I don't know that it would be a Brady violation. It really goes to a due process right to a fair trial. And what I've never seen it with respect to gunshot residue, but at the trial court it was argued, I think it was the Davis case, that involved a DUI video that went missing. And what the defense requested in this case is where the state is in possession of material evidence that it is either destroyed, lost, or somehow has gone missing through the fault of the state.
The gunshot residue, it wasn't destroyed, like lost, or going missing. There was never any evidence collected.
No, but under the circumstances of the case, it certainly should have been by the detective.
Right.
And
this is not a video that existed at some point, and I mean, the state had at some point, correct?
no, but well, they did have it. They had the body on the slab in the ME's office. And according to Dr. Bulick, he swabbed the hands, they had the GSR, and he gave it to the state. It was in their possession. So it's our contention that indeed it was destroyed, because Simpson says it never existed. Well, you have the evidence of the medical examiner, I gave it to him. So under those particular circumstances, the question then becomes, what is the remedy? And under the case law, where there's the destruction of this material evidence, the ultimate sanction would be dismissal. That wasn't requested. But however, during the charge conference in this case, there was a proposed remedy given to the court, and that was the special instruction requested by defense counsel, that if you find that material evidence was destroyed by the state, you may presume that it was exculpatory to the defendant. And you had the factual support for that evidence in the form of Dr. Bulick's testimony, and the trial court erred in failing to give that special instruction. And not only did you have the gunshot residue from the hands, you had the nail clippings from both, from Cruikshank. As I said, they never took them from Freeze. You had the diagram from Detective Apel during the interview. You have these 3 files on the state's key witness, Mr. Garrett, that at the time of this prosecution, he had 3 separate criminal matters pending, 2 worthless checks and a battery, one of which was in a separate county than the other 2. And all 3 files go missing. One of which, and the state argued, well, this is routine, it was a DPA. Well, respectfully, I disagree. Mr. Garrett had a DPA for a battery. He failed to report to the probation office according to the agreement. They issue a capias, or not a capias, an order to appear in court to explain himself. He doesn't show. They issue a capias. He's arrested and released during the midst of this case where the state knows he's a key witness. And in the course of this, then the charges are ultimately dismissed, but there's no file. And so clearly there was favorable treatment given to Mr. Garrett, and I would concur it's not a routine course of business for somebody to violate a deferred prosecution agreement numerous times, yet still get the benefit of dismissal, and it just so happens that he's a key witness in the state's murder case at the time. That's highly unusual. And so for the state not to be able to furnish these files to assist the defense in cross-examining him and testing his answers on cross-examination was key destruction of evidence that was clearly within their ambit. And that was Brady material because it was relevant to impeachment. And so you have this litany of evidence that was either destroyed or failed to be preserved, and the defense counsel sought a specific remedy for these issues in the form of the special jury instruction, and he was denied it. And this, in a case where it was hotly contested, where there's no eyewitness to...
Is there a precedent where the court has held that the failure to give such an instruction is reversible error?
As I sit here at the moment, I don't know the answer to that question, but I'd happily brief it for the court after oral argument, given leave.
Davis dealt with an issue where the case was dismissed, right? And
Yeah, that was the ultimate sanction in the failure of...
so it was really dicta, the whole suggestion that maybe an instruction would have been appropriate.
I disagree with that. I don't think it's dicta. It talks about the ranges of remedies afforded to a criminal defendant and accused in a situation where the state destroys evidence. So I don't think it's dicta.
Doesn't the reasonable doubt instruction address give the framework for the argument that the defense needed to make in this case?
Generally, but when the reasonable doubt instruction is applicable where it's a level playing field, where the state hasn't tailored its evidence solely to prosecution when it has knowledge of existence of potentially exculpatory information and just chooses to destroy it. So the reasonable doubt instruction would not cure this situation where the state has tailored the evidence, destroyed potentially exculpatory evidence, but you got your reasonable doubt and you can argue it. Well, that's not enough.
I mean, there are a lot of cases where criminal defense lawyers make the same argument that you're talking about here, which is that it was a sloppy investigation and they overlooked things that they could have found that might have been exculpatory. It would seem that as much as that comes up as a theory of defense, that if you were entitled to the instruction as a matter of law, which is what you're asking us here, that there would be some precedent that would hold as such. The best case you found is the Davis case, is that right?
Yes, sir. But in turning to that, I don't think the reasonable doubt instruction cuts it, and I don't think the Davis case is the end-all be-all. There's a litany of cases discussing states' willful destruction of evidence, and here you have that with Dr. Bulick's testimony. His testimony is unrebutted that he gave this to Detective Simpson. And so you have that established. And although it may be an abuse of discretion standard for the court's giving of a jury instruction, that discretion is somewhat limited with respect to the special instruction sought here, that if there's any evidence to support it, which there was clearly evidence, not just some scintilla.
Why should the jury be instructed that that the failure of the state to produce this evidence or preserve it gives rise to this presumption that it would have been favorable, that it would have been exculpatory? I mean, we don't have any way of knowing that it would have been exculpatory. That's just speculation, right?
And the reason why the remedy exists is because you're forced to speculate because of the state's conduct in destroying it. The defendant shouldn't be prejudiced because the state destroyed material evidence that very well could have
The
been...
instruction of the swabbing, did the defense not have the opportunity to have that tested?
The GSR?
Yeah.
No, because according to Detective Simpson, it didn't exist. But that's clearly refuted,
The examiner said he did it, but the detective said that he didn't do it.
that he never received it.
Was that addressed to the trial court in some sort of a pretrial proceeding, or is that?
I think it arose mid-trial, so it was not addressed in a pretrial proceeding. But to answer your question, that's why the instruction should be given, because the defendant shouldn't be prejudiced by the state's willful destruction of evidence. That's why the law provides a remedy to the accused in that situation. The ultimate sanction being dismissal, but there are lesser sanctions, exclusion of evidence, but in this case, the one that was...
Well, it would be helpful for us to know what happened, and we really don't. I mean, in other words, the medical examiner says I did it, Simpson says that he never had it, and we don't know whether it was lost. We don't know whether it was destroyed intentionally. We don't know whether the medical examiner was mistaken. There was no hearing and there was no findings of fact on this, right?
Well, we don't know, and that's the problem, because, and I see them in my rebuttal time, but one, under Bulick's
You
testimony...
actually used your time. The yellow light came on 5 minutes.
I apologize, Your Honor.
Thank you.
May it please the court, my name is Pam Cole, I represent the state of Florida in this appeal. As far as the state's concerned, obviously there's no reversible error in this case or fundamental error. To be honest, I don't even remember any testimony from the medical examiner during trial saying that he actually had collected any evidence from the victim's hands. I know he took pictures of them before and after he washed them off. There was testimony that the victim, when he was found, he was on his side in a fetal position. His hands were like this in his head, and he was shot back here. The gunshot came out, and there was a pool of blood that was slowly expanding when the cop came around the corner. And so his hands and the gun, because the defendant put the gun down in the pool of blood, were covered in the blood. So what relevance or benefit it would have had is pretty minimal at most. So I don't even see how he's shown that there's any evidence that's been destroyed in this case. The state explained why they did not take gunshot residue. They explained why they didn't take fingerprints or the fingernails or any of that, or fingerprints from the gun. The notepad, Detective Simpson, I guess originally, it's on the video that there's some notepad, but then Detective Simpson said, no, it was just doodles, or there was nothing there, and he just got rid of it. Obviously, the defendant would be the one in the best position to know exactly what was on that, and there was no questioning of the defendant, never proffered by the defense as to what was actually on that notepad, that he was never asked about it at all when he testified, because the defendant did testify in this case. The only thing that the defense does have right is that I can't count as far as the reputation witnesses. It was 4 out of 5 that were excluded rather than, or 4 out of 5 included rather than excluded, rather than 3. But other than that, there's no reversible error. The jury instruction is a comment on the evidence. You're not allowed to comment on the evidence in the case. And it is a misstatement. You have to show some sort of bad faith under Arizona v. Youngblood on behalf of the state of Florida, and there was no showing of bad faith. It's not like they intentionally knew that this was going to be good evidence, and so they suppressed the evidence in any way, shape, or form. They explained why they didn't do it, and it's a reasonable explanation. If this court has no questions, I'll rely on my brief and ask that you affirm.